There's a pattern in American financial history that very few people talk about, not because the evidence is missing, not because the records were destroyed, but because the pattern is documented clearly in congressional files, in bank ledgers, in personal letters written by people who lived through it. And yet it rarely appears in the conversations we have about money, institutions, and trust. The pattern repeats itself with unusual precision across different eras and different circumstances. And once you see it clearly for the first time, it becomes very difficult to unsee. The pattern has 5 steps. They do not change. First, an institution is created, specifically for people who have no other options, people who are vulnerable, people who have nowhere else to turn. Second, trust is earned, slowly, carefully, over months and years, through official language, through government endorsements, through the appearance of legitimacy. Third, the rules change, not publicly, not transparently, but quietly, behind closed doors, through amendments and adjustments that most depositors never hear about. Fourth, the money disappears. And fifth, when people begin asking questions, someone else is blamed for the loss, someone who had very little to do with the decisions that caused it. This raises an immediate question. If the pattern is documented, if the evidence exists in official records that are still accessible today, why does it remain so unfamiliar? That question does not have a simple answer, but it is worth holding on to as this story unfolds, because the answer may say something important, not just about what happened in 1865, but about how history chooses what to remember and what to quietly set aside. In March of 1865, the United States government took a significant step. Congress chartered a new financial institution called the Freedman Savings and Trust Company. It was signed into law by Abraham Lincoln on the same day as the Freedmen's Bureau, a sweeping set of promises made to 4 million people who had just been freed from slavery. The timing was deliberate. The message was clear. This was the government saying, in official language, that freedom was not just a legal status. It was something tangible, something that could be built upon. 4 million people had just been freed. Most of them had never been allowed to own a single thing. Not land, not tools, not the wages they earned, not even their own names in an official document. For these individuals, the concept of a bank account was not simply a financial tool. It was a form of recognition, a statement that their labor had value, that their future was worth investing in, that they existed as citizens in a way the law had previously refused to acknowledge. The bank was presented to them as exactly that kind of institution, a safe place, a protected place, a place the government had built specifically for them. The original charter appeared to support that promise. Deposits were to be held in government securities only, the safest financial instruments available at the time. No loans were permitted under the original rules. The money would sit untouched, protected, growing slowly and securely. A board of 50 trustees would oversee everything. On paper, the structure looked solid. On paper, it looked like a promise that was actually going to be kept. But there is a detail in that original charter that does not receive much attention. All 50 trustees were white. Not a single one was required to put up any personal security for the faithful discharge of their duties. The charter contained no penalties for mismanagement, no personal liability for trustees who made poor decisions with depositor funds, no mechanism through which depositors could hold anyone accountable if things went wrong. These were not small oversights. These were structural conditions written into the founding document of an institution created for people who had spent their entire lives in a system that offered them no legal protections whatsoever. That detail sounds minor at first, until it is examined more closely. The depositors came anyway, and they came in significant numbers. The bank's advertisements carried images of Abraham Lincoln, Ulysses Grant, and William Sherman. Its passbooks described it as a benevolent institution. Its newspaper told people this bank was conducted entirely by your best friends. For individuals who had been legally prohibited from owning property just months earlier, that language carried enormous weight. It felt official. It felt safe. It felt, for the first time, like the government was standing behind them rather than against them. Within 7 years, 37 branches had opened across 17 states and Washington, D.C. More than 70,000 people had opened accounts. Total deposits over the bank's lifetime exceeded $57 million, a figure that translates to roughly $1.5 billion in today's money. Most individual accounts held between $5 and $50. $5 represented approximately one full week of wages for many of these depositors. Former slaves saving every spare cent from their first free labor. Black soldiers depositing military pay. Churches pooling resources carefully over months. Families opening accounts for their children. Dollar by dollar, 57 million accumulated. The scale of that trust is difficult to fully comprehend. And then there is the record of Robert Harris. In 1870, in Richmond, Virginia, a man named Robert Harris walked into a Freedman's Bank branch with his wife Betsy and their 2 children. Charles was 6 years old. Mary Susan was 11. Robert had been enslaved 5 years earlier. He could not have opened a bank account before emancipation because legally, he did not exist as a person with rights. Now he was opening accounts for his children. He provided his full name, his birthplace, his occupation, his current residence. He listed his wife, his children, his parents, his brothers and sisters. For the first time in his life, his family appeared in an official record, not as property, but as people with savings and futures worth documenting. The bank required this information from every depositor. Full name, place of birth, residence, occupation, names of spouses, children, parents, siblings. For formerly enslaved depositors, sometimes the names of former owners and the plantations where they had been held. The records from 29 surviving branches contain approximately 480,000 individual names. Historians describe this as the largest single source of lineage-linked African American records known to exist. Before 1865, enslaved people could not file marriage certificates or hold land titles. They were not listed by name in federal censuses. These bank registers are, for many of the individuals named in them, the first time they appear in any official document at all. That fact becomes more significant the longer you consider it, and more complicated, for reasons that will become clear. Within 9 years of the bank's founding, it was gone. The money was gone. 61,000 depositors had approximately $2.9 million in their accounts when the doors closed. The bank had less than $50,000 in actual cash. The rest existed only in outstanding loans that would never be repaid. And the man standing at the center of the collapse, the man whose name and face became associated with the failure in public memory, was not Henry D. Cook, who chaired the finance committee and simultaneously ran his brother's investment firm. It was not J. Cook, whose bankruptcy helped trigger the final collapse. It was Frederick Douglass. Frederick Douglass was the most recognizable black man in America, a former slave who had taught himself to read, an abolitionist whose moral authority was arguably unmatched by anyone alive at that moment. He had spent his entire life fighting for black freedom in America, in speeches, in writing, in direct confrontation with power. His name meant something. His presence meant something. And in March of 1874, the white trustees of the Freedmen's Bank, the men who had watched the ledgers deteriorate for months, installed him as president. He walked into the headquarters on Lafayette Square, directly across from the Treasury Building, near the White House. He described being impressed by its towering height and perfect appointments. He felt, by his own account, like he was entering something substantial and important. He invested $10,000 of his own personal money into the institution, and then he opened the books. What he found, he later described as a corpse. Far more outstanding loans than deposits. Debts that would never be repaid. Less than $50,000 in actual cash remaining in the vault. He served as president for barely 6 weeks before telling Congress to shut the bank down. This is where the explanation becomes difficult. The white trustees who installed Douglass had access to the same books he examined. They had been watching the numbers decline for months before his arrival. They understood the condition of the institution, and yet their decision was not to warn depositors, not to attempt transparency, not to return what could still be returned. Their decision was to resign and place the most prominent black figure in America at the head of a bank they already knew was dead. Whether that decision was an act of desperation or something more calculated is a question that the historical record has never cleanly resolved. There's a version of this story that stops here and calls it a tragedy, a combination of bad policy, worse timing, and a financial panic that nobody could fully control. The Panic of 1873 was real. It destroyed thousands of institutions across America. Markets collapsed. Credit dried up. Businesses failed on a massive scale. Some argue that the Freedman's Bank was simply one casualty among many, that placing it in a separate category imposes a narrative that the evidence does not fully support. But this is where it becomes unclear. The original charter made catastrophic loss nearly impossible. Money held in government securities does not vanish during a financial panic. That is precisely why such instruments exist. For this particular bank to lose its depositors' money, someone first had to change where that money was being held. Someone had to move it from protected instruments into speculative ones. Someone had to loan it out. That did not happen by accident. It happened through a specific amendment passed by Congress in 1870, lobbied for by a specific individual with direct financial interests in the outcome. And Congress approved that amendment without adding a single additional dollar of oversight. There is a pattern in American financial history that very few people talk about. Create an institution for people who have no other options. Earn their trust, then change the rules behind their backs. Take the money, then blame someone else for the loss. That pattern is not a theory. It is in the records. It is in the ledgers and the letters and the congressional files that have survived for over 150 years. What is less clear, what remains genuinely uncertain even now, is whether what happened to the Freedman's Bank followed that pattern by accident, by negligence, or by something more deliberate than either of those explanations allows. That question, as straightforward as it sounds, has never received a satisfying answer. And perhaps that, too, is part of the story. The official explanation for what happened to the Freedman Savings and Trust Company is not complicated. It is, in fact, remarkably clean for a story that left 61,000 people without their savings. The bank was created by Congress. It served a specific and clearly defined purpose. It operated for nearly a decade, and then a nationwide financial crisis arrived, swept through the economy, and the bank collapsed along with thousands of other institutions across the country. That is the version of events most commonly offered when this story is told at all. It is tidy, it is documented at a surface level, and it leaves out a significant number of details that do not fit as neatly into that explanation as the explanation would suggest. To understand why those details matter, it helps to start at the beginning, with what the bank was actually supposed to be, and why that original design is important to the questions that come later. The Freedman Savings and Trust Company was chartered by Congress in March of 1865. The legislation was clear about its purpose. This was not a commercial bank designed to generate profit for shareholders. It was not a private investment vehicle. It was an institution created specifically to serve 4 million people who had just been legally freed from slavery, people who had never been permitted to own property, open accounts, or participate in the formal economy in any capacity. The bank existed to give them a safe, structured place to deposit whatever wages they began earning in freedom. Nothing more complicated than that. A place to put money and have it remain protected. The original charter reflected that intent. At least, that is how it appeared. Deposits were to be invested exclusively in government securities, United States bonds, treasury notes, and similar instruments. These were considered among the safest financial vehicles available at the time. They did not fluctuate dramatically with market conditions. They did not disappear in economic downturns the way private investments could. No loans were permitted under the original rules. The money deposited by formerly enslaved people was not supposed to be lent out, speculated with, or moved into anything that carried meaningful financial risk. It was meant to sit, protected, in instruments the federal government itself stood behind. A board of 50 trustees was appointed to oversee operations. On paper, this provided a layer of institutional accountability. 50 individuals responsible for ensuring the bank operated according to its charter. 50 sets of eyes on the ledgers, the deposits, the investments. That is how the structure was presented to the public and to depositors. Whether that structure functioned as described is a separate question, one that becomes more interesting the further into the record you look. For the first several years, the bank appeared to operate more or less as intended. This is worth acknowledging clearly, because the story of the Freedmen's Bank is sometimes told as if the failure was immediate or obvious from the start. It was not. Branches opened steadily across the country. Depositors came through the doors in growing numbers. Black soldiers, who had served in the Civil War, deposited their military pay. Churches and mutual aid societies pooled collective resources and opened institutional accounts. Families, many of them formerly enslaved, navigating freedom for the first time, opened accounts for their children. The activity was real. The deposits were real. The trust was real. By 1872, 7 years after the bank's founding, there were 37 active branches operating across 17 states and Washington, D.C. More than 70,000 individual accounts had been opened. The total deposits held by the bank over its entire lifetime exceeded $57 million. Adjusted for inflation, that figure represents approximately $1.5 billion in today's terms. Most individual accounts were small, $5, $10, $50 at most, but accumulated across tens of thousands of depositors over several years. The numbers became substantial. This was not a minor financial institution. This was a significant accumulation of wealth belonging to people who had, in the very recent past, been legally prohibited from accumulating anything at all. That context matters. These were not casual deposits made by people with other financial options. For the vast majority of Freedmen's Bank depositors, this was their only option. There were no alternative institutions welcoming them. There were no other government-backed savings vehicles designed for their participation. The Freedmen's Bank was, for most of its depositors, the entirety of their formal financial existence. Every dollar they placed inside it represented a decision to trust an institution that the government had created and endorsed on their behalf. That trust was not given lightly. It was built carefully, over years, through consistent participation and the belief that the structure surrounding those deposits was exactly as protective as it had been described. And then the official story says the panic of 1873 arrived and destroyed it. The panic was real. That part requires no qualification. Beginning in September of 1873, a severe financial crisis swept across the United States and much of Europe. Major banking institutions failed. Credit markets collapsed. Railroads defaulted on their debts. Businesses that had appeared stable for years found themselves unable to meet their obligations within a matter of weeks. The scale of the economic disruption was significant, and thousands of financial institutions across the country either collapsed or contracted severely during this period. The Freedmen's Bank was among those that failed. That much is accurate, but this is where it becomes unclear. The original charter of the Freedmen's Bank was specifically designed to make this kind of failure nearly impossible. Government securities, the instruments the charter required deposits to be held in, do not vanish during financial panics. That is precisely what makes them different from private investments. When markets collapse and private companies default, government-backed instruments remain. They are not immune to all pressures, but they do not simply disappear the way the Freedmen's Bank deposits did. For this bank to lose its depositors' money in the panic of 1873, something had to change before the panic arrived. The original structure, if maintained, would not have produced the outcome that occurred. At first, this seems like it might have a simple explanation. Banks sometimes drift from their original charters. Oversight weakens over time. Rules that seemed firm become flexible under financial pressure. That kind of institutional drift is not unusual in financial history. Some argue that this is precisely what happened, that the Freedmen's Bank gradually moved away from its original protective structure through a combination of poor judgment, inadequate oversight, and the general financial pressures of the era. This explanation is not unreasonable on its surface, but there is a problem with accepting it too quickly. The shift away from the original charter was not gradual. It was specific. It happened on a specific date, through a specific legislative action, lobbied for by a specific individual with clearly documented financial interests in the outcome. On May 2, 1870, Congress amended the Freedmen's Bank Charter. The amendment permitted half of all deposits to be loaned out for real estate investments. This was not institutional drift. This was a deliberate structural change that opened the bank's deposits to exactly the kind of risk the original charter had been designed to eliminate, and Congress approved it without adding a single additional dollar of oversight or accountability. That raises questions that the official explanation does not fully address. If the original charter was protective, and the bank appeared to be functioning as intended through the late 1860s, why was the amendment necessary? What problem was it solving? Who identified the need for it? And who stood to benefit from the change? The official record on these questions exists. It is not hidden, but it is also not frequently discussed in the same sentence as the Panic of 1873, when the bank's collapse is explained. The accepted narrative treats the panic as the cause, and the bank's failure as the effect. That sequence is clean. It places the collapse within a broader economic context that affected many institutions simultaneously, which makes the Freedman's Bank failure feel like an unfortunate but understandable casualty of forces that nobody could fully control. What that framing does not account for is the period between 1870 and 1873, the 3 years between the charter amendment and the panic, during which the bank's deposits were moved into precisely the kinds of investments that would become worthless when the crisis arrived. Something worth sitting with. If the charter had never been amended, the panic would likely have left the Freedman's Bank largely intact. The deposits would have remained in government securities. 61,000 depositors would have retained access to their savings. The panic would have passed, as panics do, and the bank might have continued operating. That is not speculation about what should have happened. It is an observation about what the original structure was designed to prevent. The amendment removed that protection, and the panic arrived 3 years later. Whether those two facts are connected by coincidence, by negligence, or by something more deliberate is a question the official explanation does not answer directly. It tends not to raise the question at all. The Panic of 1873 is presented as the beginning of the story's ending, rather than as the final step in a sequence that had already been set in motion years earlier. That framing shapes what conclusions seem reasonable and what questions seem worth asking. There are historians who accept the official explanation largely as stated. They point to the complexity of the 1873 crisis, the general atmosphere of financial recklessness in that era, and the genuine difficulty of managing a nationwide banking network serving a newly freed population with limited resources. These are not frivolous arguments. The context was genuinely difficult, and the failures were not entirely unique to this institution. But others look at the same record and find the official explanation insufficient. They point to the specific individuals involved in the 1870 amendment, the specific loans that followed it, and the specific pattern of decisions made by the bank's trustees in the years between the amendment and the collapse. They argue that treating the panic as the primary cause obscures a more complicated sequence of events that unfolded before September 1873. The difficulty is that both readings are partially supported by the available evidence. The panic was real and the timing was damaging. The charter amendment was also real, and its consequences were predictable. These two things are not mutually exclusive, but the official explanation tends to emphasize one and minimize the other. And that imbalance is worth noticing, not because it proves a particular conclusion, but because it shapes which questions get asked and which ones remain, for the most part, unanswered. What the record shows clearly is this. A bank was created with protective rules. Those rules were changed. The money moved into riskier investments. A crisis arrived. The money was gone. 61,000 people lost their savings. That sequence is documented. What is less clear, and what the official explanation does not fully resolve, is the relationship between each of those steps. Whether the connections were incidental or intentional remains, even now, an open question. And open questions, especially ones attached to $57 million and 61,000 depositors, tend to be worth following a little further. The first problem with the official explanation is not a minor detail. It is not a small inconsistency that can be set aside without affecting the larger picture. It sits directly at the center of the story, and once it is identified clearly, the accepted version of events becomes significantly harder to accept without further questions. The official explanation says the Freedman's Bank collapsed because of the Panic of 1873, a nationwide financial crisis, a disaster that affected thousands of institutions simultaneously. something that nobody could have fully anticipated or prevented. That explanation is not entirely wrong. The panic was real. The economic damage was widespread. But there is a fundamental problem with applying that explanation to this particular bank, and the problem has to do with the original design of the institution itself. The Freedman Savings and Trust Company was not structured like a typical private bank. Its original charter placed strict limitations on where depositor funds could be held. The money was required to go into government securities, United States bonds, treasury notes, and similar instruments backed directly by the federal government. This was not an accident of design. It was a deliberate choice, written into the founding document of the institution, intended to ensure that depositor funds could not be lost in the kinds of financial disruptions that periodically swept through private markets. Government securities do not vanish during a financial panic. That is the entire point of them. When private companies default and private investments collapse, government-backed instruments continue to hold their value. They exist precisely because markets are unstable and something needs to remain standing when they fall. This means something important. If the Freedmen's Bank had maintained its original charter, if deposits had remained in government securities exactly as the founding rules required, the Panic of 1873 would likely not have destroyed it. The panic would have arrived. It would have caused damage across the broader economy, and the Freedmen's Bank deposits would, in all likelihood, have remained intact. The original structure was not a guarantee against every possible outcome, but it was specifically designed to prevent the kind of total loss that actually occurred. For the bank to lose its depositors' money, something had to change before the panic arrived. The structure had to be altered. The protections had to be removed. And that is exactly what happened. On May 2, 1870, Congress amended the Freedmen's Bank Charter. The amendment permitted up to half of all deposits to be loaned out for real estate investments. This was a significant structural change. It transformed the bank from an institution where deposits sat in protected government instruments into one where half of all depositor funds could be placed into loans. Loans that could default. Loans attached to properties whose value could fall. Loans that carried exactly the kind of risk the original charter had been built to eliminate. The amendment did not come with additional oversight mechanisms. It did not come with new accountability requirements. It did not come with any increased protection for the depositors, whose money was now exposed to substantially greater risk. Congress approved the change and moved on. At first, this seems like it might simply reflect the financial thinking of the era. The early 1870s were a period of significant economic expansion in the United States. Real estate investment was considered a growth opportunity. Banks across the country were extending credit and taking on greater risk as the post-war economy developed. Some historians argue that the Charter Amendment was a product of that broader environment, an attempt to allow the Freedmen's Bank to generate returns that could benefit depositors, consistent with how other financial institutions were operating at the time. That argument is not unreasonable, but there's a problem with stopping there. The question that does not get asked often enough is a simple one. Who pushed for that amendment? The answer is in the congressional record. It is not hidden or difficult to find. The man who lobbied Congress for the 1870 charter change was Henry D. Cook. At the time, Henry Cook served as the chairman of the Freedmen's Bank's Finance Committee. That position gave him direct oversight of how the bank's funds were managed and invested. It gave him access to the deposit ledgers. It gave him a formal role in the decisions that followed the amendment. And it is worth pausing on that before moving to the next detail, because the next detail changes the nature of the question considerably. Henry D. Cook was the brother of J. Cook. J. Cook was the founder of J. Cook & Company, the most powerful private investment bank in the United States at that time. J. Cook & Company had helped finance the Union side of the Civil War by marketing government bonds directly to ordinary citizens, a strategy that had made the firm enormously influential and deeply connected to political power in Washington. By 1870, the firm was heavily involved in financing the Northern Pacific Railroad, an ambitious and expensive project that required substantial investment capital to continue moving forward. The railroad needed money. J. Cook's firm needed access to funds it could deploy into that project and others like it. Henry Cook sat on the finance committee of the Freedmen's Bank. His brother's firm needed investment capital. Henry Cook lobbied Congress for an amendment that allowed Freedman's bank deposits to be loaned out. Congress approved the amendment. That is the sequence. Each individual step has a documented explanation. But when the steps are placed in order and the relationships between the people involved are made clear, the sequence becomes more difficult to read as a simple series of unrelated decisions. That detail sounds minor at first, the relationship between two brothers, one running a finance committee, one running an investment bank, until it is examined more closely. Henry Cook was not simply Jay Cook's brother in a general biographical sense. He was simultaneously occupying multiple institutional positions that intersected directly with the decisions being made about Freedman's bank deposits. He chaired the bank's finance committee. He was also, at this same period, the territorial governor of Washington, D.C., a position to which he had been appointed by his close associate Ulysses Grant. He was additionally serving as president of First National Bank in Washington, which functioned as Jay Cook and Company's local office in the capital. He sat on the boards of organizations that would subsequently receive loans from the very deposits he oversaw. He was, in a documented and verifiable sense, positioned on multiple sides of the transactions that followed the Charter Amendment. This raises questions, not accusations, questions. When a single individual simultaneously controls the finance committee of one institution, the branch of a related investment firm, and a government appointment in the same city, the decisions that flow through those overlapping roles become difficult to evaluate in isolation. Each decision might look reasonable when examined on its own, but the pattern of decisions, made by the same person sitting at the intersection of multiple conflicting interests, requires a different kind of scrutiny than the official explanation typically applies. And this is where the explanation becomes difficult. The standard framework for understanding the Freedman's bank collapse treats Henry Cook's various roles as background context, relevant perhaps to understanding how the bank operated, but not necessarily indicative of deliberate wrongdoing. Some historians have been careful to note that the era was characterized by overlapping business relationships, and that what looks like a conflict of interest today was sometimes accepted practice in the 1870s. That observation is historically fair. The norms governing financial relationships were different, and not every overlap between business roles in that period reflected corrupt intent. But there is a difference between overlapping roles that exist because of the way business was commonly conducted and overlapping roles that place one individual in direct control of both the institution providing funds and the institutions receiving them. Henry Cook was not simply connected to multiple organizations in a general network sense. He was positioned to influence decisions on both the lending side and the receiving side of specific transactions. And the amendment that made those transactions possible was one he had personally lobbied Congress to approve. Congress approved the amendment without increasing oversight by a single mechanism. No additional reporting requirements were introduced. No new accountability structures were created for a situation that now involved significantly greater risk to depositor funds. The 50 trustees continued to operate under the same charter conditions that had included no personal liability for mismanagement. The money was now available to be loaned, and it was loaned in directions that become clearer when the post-amendment financial records are examined. However, the timeline does not fully match the simplest version of events. If the amendment was intended as a good faith effort to allow the bank to generate returns for its depositors, the subsequent loan decisions would be expected to reflect some balance between risk and protection of depositor interests. What the records show instead is a pattern of loans that flowed consistently toward entities connected to the individuals making the lending decisions. Not universally, not in every case, but with enough regularity that the pattern becomes noticeable once the connections between the borrowers and the decision-makers are mapped. Some believe this pattern reflects deliberate coordination. Others argue it reflects the informal networks through which business was conducted in Washington during that period. That people in positions of financial authority naturally directed capital toward ventures they were personally familiar with, and that this was not considered unusual at the time. Both interpretations are represented in the historical literature. Neither has been definitively settled, and that is precisely where the uncertainty in this story lives. What can be stated clearly, without reaching beyond the documented record, is this. The original charter made catastrophic loss extremely unlikely. The amendment removed that protection. The man who lobbied for the amendment held simultaneous positions on both the lending side and the receiving side of the transactions that followed. Congress approved the change without adding any accountability mechanisms. And when the panic of 1873 arrived 3 years later, the deposits that might have been protected were not, because they were no longer held in the instruments the original charter had required. Whether the 1870 amendment was a policy miscalculation, an act of negligence, or something more deliberately self-interested is a question that the available evidence approaches, but does not fully answer. The congressional record documents who lobbied for the change. The financial records document where the money went afterward. The biographical record documents the relationships between the individuals involved. What those documents cannot provide on their own is certainty about intent. And without certainty about intent, the official explanation that this was primarily a story about an economic panic remains available as a framing, even as it leaves significant portions of the documented sequence unaddressed. That overlap between what the records show and what the explanation accounts for is difficult to call a coincidence, but it is also, in the strictest evidentiary sense, difficult to prove was anything more deliberate. And it is precisely in that space between what is documented and what is provable that this story becomes genuinely unclear. The records exist. The connections are visible. The sequence is documented. What remains uncertain is the question that sits underneath all of it, whether the people who changed the rules understood exactly what those changes would produce, and made them anyway. To understand why the collapse of the Freedmen's Bank matters in a way that goes beyond ordinary financial history, it is necessary to understand who the depositors actually were, not in a general sense, not as a category or a demographic, but as specific people making specific decisions under specific circumstances that are worth examining carefully before moving further into the story of what happened to their money. The depositors of the Freedmen's Bank were not wealthy individuals seeking investment returns. They were not people with diversified financial portfolios who placed a portion of their assets in one institution among several. For the vast majority of people who walked through the doors of a Freedmen's Bank branch and opened an account, this was not one financial decision among many. It was, in most cases, their only financial decision, their only formal engagement with the economic system of the country that had just, very recently, recognized them as citizens rather than property. Most individual accounts held between $5 and $50. That range requires some context to fully appreciate. $5, in the years immediately following the Civil War, represented approximately 1 full week of wages for many of the people depositing it. A week of labor, a week of showing up, working, and receiving payment for the first time in a life that had previously involved the same labor without any payment at all. When someone deposited $5 into a Freedmen's Bank account, they were not making a casual financial decision. They were taking an entire week's worth of newly earned wages and placing it in the care of an institution they had been told was safe. That is not a small act. It is an act of significant trust, made by people who had very little margin for error if that trust turned out to be misplaced. Former slaves were saving every spare cent from their first free labor. That phrase is easy to read quickly and move past, but it is worth slowing down on. These were individuals who had spent years, decades, sometimes entire lifetimes, working without compensation, without legal recognition, without any mechanism for accumulating anything at all. The moment they received wages for the first time, they began saving. Not because saving was easy. It was not. The economic conditions facing formerly enslaved people in the post-war South were extremely difficult. Employment was often unstable. Pay was often inadequate. The broader environment was frequently hostile to black economic progress in ways that were both informal and formally enforced. And yet they saved. Week after week, dollar by dollar, in amounts that might seem small in isolation but represented genuine sacrifice, made consistently over time. Black soldiers were also among the depositors, men who had served in the Union Army during the Civil War, who had earned military pay in exchange for service rendered under conditions that were, in many documented cases, more dangerous and less compensated than the conditions facing white soldiers in the same conflict. These men deposited their military pay into the Freedman's bank. They did so because the bank carried the endorsement of the government they had just served. That connection between military service, government endorsement, and financial trust is worth holding in mind. These were not naive depositors. They were people who had made real contributions and were making rational decisions based on the information available to them. Mutual aid societies also participated. These were community organizations, groups of people pooling resources collectively to provide support to members during illness, death, or financial hardship. They operated on the principle that collective saving created collective security. When these organizations opened accounts at the Freedman's Bank, they were not depositing individual savings. They were depositing the pooled resources of entire communities. The loss of those funds, when it came, would not fall on one person. It would fall on everyone who had contributed to and depended on that collective reserve. The bank understood exactly who its depositors were. That is an important point, and it is supported by the institution's own public communications. The bank's advertisements did not present it as a neutral financial service. They carried images of Abraham Lincoln, Ulysses Grant, and William Sherman, three of the most recognizable figures of Union authority in the country. These were not random endorsements. Lincoln had signed the charter. Grant was the sitting president. Sherman was the general whose campaigns through the South had been directly linked, in public memory and in the promises made to freed people, to the idea of a new economic order. Placing their faces on bank advertisements was a deliberate choice, designed to communicate a specific message. This institution has the backing of the most powerful people in the United States government. Your money is as safe here as it would be anywhere. The bank's passbooks, the small documents handed to every depositor as a record of their account, describe the institution as a benevolent institution. The bank's own newspaper told readers that they should deposit because this bank was conducted entirely by your best friends. These were not offhand descriptions. They were carefully chosen words directed at a specific audience. For people who had spent their entire lives in a legal and social system that explicitly denied them protection, friendship, and recognition. Language like that carried weight that is difficult to fully measure from this distance. It was not just advertising. It was a promise delivered in the language of official authority. And this is where it becomes unclear. The bank presented itself as a government-backed institution operating in the interests of its depositors. The images of Lincoln and Grant suggested official endorsement. The language of benevolence suggested protection. But the actual structure of the institution, the charter with no personal liability for trustees, no penalties for mismanagement, no mechanisms for depositor accountability, did not match the warmth of the public messaging. There was a gap between what the bank said it was and what its founding documents actually guaranteed. That gap was not visible to depositors. It was not explained in the passbooks or the advertisements. Most people who walked in and opened accounts had no reason to suspect it existed. For people who had been legally prohibited from owning property just months earlier, the language carried enormous weight. It is worth being precise about what that prohibition had meant in practice. Before emancipation, enslaved people could not legally own land, hold bank accounts, sign contracts, file marriage certificates, or appear in official documents as individuals with rights. Their existence in the formal record was as property belonging to someone else, not as people with names and futures of their own. The Freedman's Bank arrived in the immediate aftermath of that system and offered them something that looked, from every available angle, like full participation in the economic life of the country. A place where their names were written down. A place where their wages were held. A place where their futures could, in a concrete financial sense, begin to take shape. They responded accordingly. Depositors came in steadily increasing numbers through the late 1860s and into the early 1870s. They deposited week after week, year after year, not because they had been given financial advice, suggesting it was the optimal strategy, but because the institution presented itself as trustworthy, government-endorsed, and specifically designed for them, and because, for most of them, there was no comparable alternative. Trust in this context was not passive. It was an active, ongoing decision, renewed with every deposit, sustained by the consistent messaging that the bank and its official-looking materials projected. There's also something else worth noting, and it sits somewhat separately from the financial story. Every depositor was required to provide detailed personal information when opening an account: full name, place of birth, current residence, occupation, names of spouses, children, parents, and siblings. For formerly enslaved depositors, the records sometimes also included the names of former owners and the plantations where they had been held. This was presented as a standard administrative requirement, information needed to identify depositors or their heirs in case of death or dispute. It was framed as a protection, a way of ensuring the right people receive the right funds. The records from 29 surviving branches contain approximately 480,000 individual names. Historians who have examined these documents describe them as the largest single source of lineage-linked African American records known to exist from this period. Before 1865, enslaved people could not file marriage certificates. They were not listed by name in federal censuses. They did not appear in land records or legal documents as individuals with identities the state recognized. For the vast majority of people whose names appear in the Freedman's bank records, this was the first time they were documented in any official capacity anywhere. First name, last name, family members, place of origin, written down and preserved in the ledgers of a financial institution. That fact is significant on its own, but it becomes more complicated the longer you sit with it. The same institution that collected this information, the most comprehensive record of post-emancipation black family life ever assembled, was also the institution that lost its depositors' money through a sequence of decisions made by trustees who faced no personal accountability for the outcome. The record survived. The money did not. The names were preserved. The savings were gone. Those two facts exist together in the same archive, in the same ledgers, and the relationship between them does not resolve easily into a simple conclusion. Some researchers have noted that the survival of these records, while historically significant, raises its own questions. The information was collected from people who trusted the institution with both their money and their personal histories. They provided family names, former plantation names, the names of people they had been separated from during slavery. They did so because they believed the institution was operating in their interest. Whether the collection of that information served the depositors who provided it, or primarily served the administrative needs of an institution whose trustees faced no liability for its eventual failure, is a question the records themselves cannot fully answer. What the records do show, clearly and in significant detail, is who the depositors were. They were people saving on the smallest possible margins, people whose trust was earned through official imagery and government-adjacent language, people whose deposits represented not just money, but a decision to believe that freedom meant something durable and protected. They deposited week after week because the institution told them it was safe, because Lincoln's face was in the advertisement, because the passbook said benevolent institution, because the newspaper said your best friends, and because, for people with no other options and no comparable alternative, the Freedman's Bank was the only place the promise of economic freedom had been given a physical address. That context does not change what happened to the money, but it does change what the loss of that money actually meant, and that distinction matters, perhaps more than the official explanation has ever fully acknowledged. Some inconsistencies in this story are difficult to explain away cleanly, not because the records are incomplete or the timeline is unclear. The records exist. The timeline is documented. The inconsistencies are visible precisely because the evidence is available, sitting in congressional files, in bank ledgers, in the biographical records of the people who made the decisions. The problem is not a lack of information. The problem is that when the available information is placed in sequence and examined carefully, the explanation that is most commonly offered does not fully account for what the documents show. It is worth starting with the structure of the original charter, because that is where the first inconsistency appears, and it appears before the bank even opened its doors to a single depositor. The Freedman Savings and Trust Company was created specifically to serve people who had no legal protections, no financial experience, and no alternative institutions willing to serve them. That was the stated purpose. A bank for the most vulnerable population in the country, people who had just emerged from a system that had denied them every form of legal recognition. Given that purpose, it would be reasonable to expect the founding document to include strong protective mechanisms accountability structures, oversight requirements, consequences for mismanagement. Reasonable to expect, but not what the charter actually contained. All 50 trustees appointed to oversee the bank were white. Not one was required to put up any personal security for the faithful discharge of their duties. That phrase, faithful discharge of their duties, appears in the kind of formal institutional language that sounds protective without actually providing any protection. A requirement without a guarantee. A standard without a consequence. The charter contained no penalties for mismanagement, no personal liability for trustees who made poor decisions with depositor funds, no mechanism through which depositors could hold anyone accountable if the institution failed to protect their money. These were not minor gaps in an otherwise solid document. They were fundamental absences in a charter designed for people who had no other recourse if those protections turned out to be necessary. Abraham Lincoln signed that charter 5 weeks before his assassination. That timing is not itself suspicious. The signing was a legislative event, not connected to what followed. But it is worth noting because it marks the moment when the institution became official, and because what Lincoln signed was already structurally vulnerable in ways that received almost no public attention at the time. The advertisements showed his face. The institution carried the weight of his endorsement. Depositors associated the bank with his authority, but the document he signed did not include the accountability mechanisms that would have made that association meaningful in practical terms. There's no evidence Lincoln was aware of those structural gaps. There's also no record that anyone raised them publicly during the charter's passage through Congress. Now consider the 1870 amendment in light of what the charter already lacked. By the time Henry Cook lobbied Congress to allow deposits to be loaned out, the institution already operated without personal liability for trustees, without penalties for mismanagement, and without any mechanism for depositor accountability. The amendment did not introduce those absences. They were already present. What the amendment did was expand the scope of decisions that trustees could make with depositor funds, while leaving the absence of accountability entirely unchanged. More risk, same lack of consequences. That combination is worth examining. Henry Cook's position at the time of the amendment is documented in multiple sources. He was simultaneously the chairman of the Freedmen's Bank's Finance Committee, the territorial governor of Washington, D.C., a position to which he had been appointed by his close associate Ulysses Grant, and the president of First National Bank in Washington, which served as J. Cook and Company's local office in the capital. 3 significant institutional roles, all held at the same time, all intersecting directly with the decisions being made about Freedmen's bank deposits. That detail sounds minor at first, until it is examined more closely, and the transactions that followed the amendment are traced through the records. He sat on every side of every significant transaction that followed the charter amendment. That is not a figure of speech. It is a description of his documented institutional positions relative to the money flows that occurred after May 1870. He oversaw the bank's finances as chairman of the Finance Committee. He received deposits at First National Bank as its president. He operated within the political structure of Washington as its appointed governor. Each role gave him access to a different piece of the same system, and the decisions made through those roles moved money in directions that consistently benefited the institutions connected to him and his brother. After the amendment passed, Henry Cook deposited up to $500,000 of Freedman's bank cash at First National Bank. $500,000 of money belonging to formerly enslaved depositors, held in his brother's local banking office, under arrangements that Cook himself had authority to approve from his position on the Finance Committee. The Cook brothers paid 5% interest on that money. The Freedman's Bank had promised its depositors 6%. That 1% difference, small as it sounds in isolation, came directly out of depositor savings. Every percentage point paid to depositors above what First National Bank was returning to the Freedman's Bank was a net drain on the funds belonging to the people the institution was created to serve. At first, this seems like poor financial management. A bad deal, perhaps. A miscalculation about returns. Something that might reflect incompetence rather than anything more deliberate. That interpretation is available, and some historians have applied it. But there's a problem with stopping there. Poor financial management implies that the decision-maker was trying to achieve a good outcome and failed. It implies an attempt to serve depositor interests that simply went wrong. But the arrangement between the Freedman's Bank and First National Bank was not made by someone who lacked information about the relationship between the two institutions. Henry Cook was president of First National Bank. He knew exactly what interest rate his brother's institution was paying. He knew exactly what rate his depositors had been promised. He approved the arrangement anyway. These were not accidental arrangements. They were deliberate decisions made by the same man, sitting on multiple boards simultaneously. And that distinction between accidental and deliberate is precisely where the explanation starts to weaken. An accidental arrangement might be forgiven as the product of genuine confusion or poor judgment. A deliberate arrangement made by someone who understood all sides of the transaction requires a different kind of explanation. The question is not whether Cook understood what he was doing. The records suggest he understood it clearly. The question is what that understanding tells us about the nature of the decisions being made. But this is where it becomes unclear. Establishing that an arrangement was deliberate is not the same as establishing that it was corrupt in intent. Some argue that Cook genuinely believed the bank could generate better long-term returns for depositors by placing funds at First National Bank, even at a loss of 1 percentage point, because of other benefits the relationship provided. Others point to the pattern of decisions that followed and argue that the consistent movement of funds toward Cook-affiliated institutions, under arrangements that Cook himself approved from multiple positions simultaneously, reflects something more than a belief in long-term depositor benefit. Neither interpretation has been definitively settled by the available evidence. What makes this particular inconsistency difficult to dismiss is the cumulative nature of the overlap. If Henry Cook had been only the Finance Committee chairman, the arrangement with First National Bank might be read as a straightforward error in institutional decision-making. If he had been only the governor of Washington, D.C., his relationship with J. Cook's firm might be considered background context. But he occupied all of these roles at the same time. Every position he held gave him a different form of access to the same pool of depositor money. And the decisions that flowed through those positions consistently moved that money in directions that reduced its availability for the people who had deposited it. There is also the question of what the other 49 trustees were doing during this period. The charter placed 50 trustees in oversight positions. If one trustee was making decisions that created structural losses for depositors, the remaining 49 had access to the same ledgers and the same information. Some historians have noted that the board was largely passive, that active oversight was effectively concentrated in the Finance Committee chaired by Cook, and that the broader board of trustees did not exercise meaningful scrutiny over the specific transactions being approved. Whether that passivity reflects genuine inattention, a lack of information, or something more comfortable for the trustees involved is another question the record does not cleanly resolve. However, the timeline does not fully match the simplest version of events. If the trustees were genuinely unaware of the problems developing inside the bank's finances, that unawareness becomes harder to explain as the years passed and the ledgers became increasingly difficult to read as anything other than a record of accumulating losses. By 1873, roughly 3 years after the amendment, approximately 75% of all outstanding loans were overdue. That figure was not hidden in obscure records. It was visible to anyone examining the bank's books. The question of what the trustees knew, and when they knew it, is one that the subsequent congressional investigation raised without ever producing satisfying answers. And that is where the inconsistencies in this story begin to accumulate into something that is genuinely difficult to explain through any single straightforward framework. The charter was designed without accountability. The amendment was lobbied for by someone positioned on multiple sides of the resulting transactions. The money moved in directions that consistently reduced the funds available to depositors. The trustees with formal oversight responsibility did not appear to intervene. And when the institution eventually failed, not one person with formal authority over those decisions faced legal consequences for them. Each of those facts has an available explanation that stops short of the most serious interpretations. Poor design, common practice, bad timing, passive oversight, a financial panic that nobody predicted precisely. But when those explanations are placed side by side against the documented sequence of decisions and the documented positions of the people who made them, the picture that emerges does not resolve into something comfortable. It remains open, contested, uncertain in ways that the official version of the story tends to minimize. And that uncertainty, sitting inside a documented record that has been available for over 150 years, raises a question that is surprisingly difficult to answer. Not just about what happened, but about why the explanation that has been most commonly offered has asked so few questions about it. Follow the money further, and the picture becomes more difficult to dismiss. Not because the individual transactions are impossible to explain in isolation. Each one, examined on its own, might be read as a poor decision, a miscalculation, or an unfortunate product of the financial environment of the era. But when the transactions are placed in sequence, when the names attached to the lending decisions are compared against the names attached to the receiving institutions, and when the pattern that emerges is measured against the stated purpose of the bank making those decisions, the picture that forms is harder to set aside as ordinary mismanagement. The place to start is with specific numbers, not general descriptions of financial loss, but the actual figures recorded in the ledgers that survive, because the money did not simply evaporate in a panic. It moved. It went somewhere, and the records, imperfect as they are, show where significant portions of it went and who was positioned on the receiving end of those movements. $50,000 of Freedman's bank depositor funds went to J. Cook and Company for the Northern Pacific Railroad. That transaction requires some unpacking. J. Cook and Company was the most powerful private investment bank in the United States at the time. Its founder, J. Cook, had built his reputation financing the Union side of the Civil War. By the early 1870s, the firm was deeply committed to the Northern Pacific Railroad, an ambitious infrastructure project stretching across the northern United States toward the Pacific coast. The railroad required enormous amounts of capital to continue construction. J. Cook's firm was the primary vehicle through which that capital was being raised and deployed. The railroad was, in financial terms, the firm's largest and most consequential bet, and it needed money. The $50,000 from Freedman's bank depositor funds was secured by bonds. That detail matters because secured loans are supposed to be protected. The collateral exists so that if the borrower cannot repay, the lender can recover value through the security attached to the loan. But the bonds used to secure this particular transaction were later described, by people who examined them after the collapse, as worthless, which means the $50,000 left to Freedman's bank went to J. Cook's firm and was backed by instruments that could not cover the loss if the loan went bad. And the loan went bad. The question of who assessed the value of those bonds before the transaction was approved, and what that assessment actually concluded, is one the surviving records do not answer with any clarity. Another $50,000 went to the Seneca Sandstone Company. This is a smaller and less frequently discussed transaction, but it is in some ways the most direct illustration of the structural problem at the center of these decisions. The Seneca Sandstone Company was not an established institution that applied for a loan through normal banking channels. It was an organization that Henry Cook himself had created. He sat on the board of the Freedman's Bank's Finance Committee, the body that approved lending decisions. He also sat on the board of the Seneca Sandstone Company, the organization that received the funds. He was, in the most literal documentary sense, on both sides of that transaction simultaneously. The institution lending the money and the organization receiving it shared a common figure in positions of authority over both. That detail sounds minor at first, until it is examined more closely and placed alongside the other transactions following the same pattern. $224,000 went to the contractor building the bank's own headquarters. The headquarters itself was a brownstone building on Pennsylvania Avenue in Washington, D.C., eventually valued at approximately $260,000. It sat at one of the most prominent addresses in the Capitol, near the Treasury Building, near the White House, on one of the most recognizable streets in the country. It was an impressive structure. It projected exactly the kind of institutional solidity and permanence that a bank trying to earn the trust of formerly enslaved depositors would want to project, and it was paid for entirely with depositor money. The same money that $5 a week wage earners had placed in the bank for safekeeping was used to construct a building whose primary function was to make the institution look more trustworthy than the state of its finances warranted. Bank officials also approved personal loans to themselves and to close associates. This is documented in the records, though the full scope of these arrangements is difficult to reconstruct completely because of the condition of the ledgers by the time independent examiners gained access to them. What is clear is that individuals with formal authority over lending decisions used that authority to direct funds toward themselves and toward people connected to them personally and professionally. That pattern, decision-makers approving their own access to the funds they oversaw, is not unique to the Freedman's Bank in the financial history of that era. But in this particular institution, it occurred against a backdrop of no personal liability, no penalties for mismanagement, and no depositor mechanism for accountability. The structural conditions that might have deterred or exposed this kind of self-dealing were precisely the ones that the original charter had failed to include. And this is where the explanation becomes difficult, because alongside the loans flowing toward Cook-affiliated companies, railroad bonds, personal associates, and headquarters construction, there's a detail in the records that does not fit comfortably into the framework of simple financial mismanagement. The few black depositors who attempted to borrow from their own bank, the institution chartered specifically for their benefit, carrying their deposits, presenting itself as their financial home, faced significantly stricter collateral requirements than the white men who were actively directing funds out of the same institution. This was not a minor procedural inconsistency. It was a structural disparity operating inside an institution whose public identity was built entirely on the premise of serving black depositors. The people whose money funded the institution's loans were, when they sought to access those same loan facilities, held to standards that the institution's white beneficiaries were not. That detail sits in the record without a clean explanation. Some argue it reflects the broader racial dynamics of the financial system in that period, that the Freedman's Bank was operating within a context of systemic discrimination that shaped its internal practices regardless of its stated mission. Others note that the specific contrast, stricter requirements for black borrowers inside an institution taking looser approaches with white borrowers, is particularly difficult to explain as a product of external context alone when the institution's entire reason for existing was to serve the people being held to stricter standards. The explanation does not fully resolve the contradiction. By 1873, roughly 75% of all loans on the bank's books were overdue. That figure, drawn from the records of the institution itself, represents a state of financial deterioration that would have been visible to anyone examining the ledgers. 75% overdue is not an early warning sign. It is not an indicator of a developing problem that might still be corrected. It is a description of an institution that had already, in practical terms, failed to recover the money it had lent out. The vault was nearly empty. The financial records had become, in the words of people who examined them after the collapse, largely fictional. Numbers that did not correspond to actual assets, balances that existed on paper, but not in the deposit boxes they purported to represent. The institution that 61,000 people trusted with their savings was, by the time the panic arrived, already a record of losses dressed in the language of an operating bank. And then on September 18, 1873, J. Cook and Company declared bankruptcy. The Northern Pacific Railroad could not repay its debts. The firm that had borrowed $50,000 of Freedman's bank depositor funds, secured by bonds later described as worthless, collapsed. The bankruptcy of J. Cook and Company is widely considered the triggering event of the Panic of 1873. Markets reacted immediately. Credit contracted. Institutions that had extended funds into Cook-affiliated ventures found those funds suddenly unrecoverable. The panic spread with the speed characteristic of financial crises, and the Freedman's Bank was among the first institutions to collapse in its wake. However, the timeline does not fully match the simplest version of events. Henry Cook resigned as territorial governor of Washington, D.C. on September 10, 1873, 8 days before his brother's firm declared bankruptcy, 8 days before the panic that the official explanation identifies as the cause of the Freedman's Bank collapse. He resigned from his government position, the position to which he had been appointed by Ulysses Grant, the position that had formed one corner of his simultaneous institutional presence, 8 days before the event that the official narrative treats as the unforeseen crisis that brought down the bank. This raises questions that the official explanation has never fully resolved. A resignation timed 8 days before a bankruptcy that triggered a national financial panic suggests access to information about what was coming. It suggests that the person resigning understood, before the general public did, that the firm whose deposits he had been directing and whose affiliated companies he had been funding was about to fail in a way that would have significant consequences. Whether that advanced knowledge was based on insider information, on a reasonable reading of publicly available financial signals, or on something more directly connected to the decisions that had been made over the preceding 3 years, is a question the record does not answer with certainty. Some argue that the timing of the resignation was coincidental, that Henry Cook had other reasons for stepping down from the governorship, and that the proximity to his brother's bankruptcy reflects unfortunate timing rather than foreknowledge. Others find it difficult to accept that reading given the documented relationships between all the parties involved, the pattern of financial decisions that had moved Freedman's bank deposits toward Cook-affiliated ventures, and the precision of the 8-day interval. The gap between those two interpretations has not been closed by anything the surviving records contain. What is not disputed is the outcome. The bank collapsed. The depositors lost their money. The vault that had held the savings of 61,000 people was nearly empty when the doors finally closed. And the sequence of transactions that had emptied it, the railroad bonds, the sandstone company, the headquarters construction, the personal loans, the differential treatment of black borrowers, had all occurred under the oversight of trustees who faced no personal liability for any of it. The structural conditions that might have created accountability were absent from the beginning. The transactions that moved the money happened within that absence. And when the collapse came, the explanation offered to the public focused on the panic, the external crisis that arrived in September 1873, rather than on the 3 years of internal decisions that had left the bank unable to withstand it. That framing has persisted. It shapes how the story is most commonly told. But the records that sit in archives today, the ledger entries, the loan approvals, the board minutes, the resignation dates, tell a more complicated sequence. One that begins before September 1873 and involves decisions made by identifiable people in documented positions of authority. Whether those decisions represent negligence, self-interest, or something more deliberately coordinated remains, in the strictest evidentiary sense, an open question. But it is an open question with a great deal of documented context surrounding it. And that context makes the simple version of the story, the panic arrived, the bank failed, increasingly difficult to accept as a complete account of what actually happened. By early 1874, a pattern had become visible inside the Freedman's bank that was not being discussed in any public forum, not in the bank's own newspaper, which continued presenting the institution in reassuring language, not in the official communications reaching branch offices across the country, not in any statement directed toward the 61,000 depositors who were still walking through bank doors, still making deposits, still trusting that the structure surrounding their savings was functioning as it had been described to them. The pattern was visible in the ledgers. It was visible to anyone with access to the actual numbers. And the people with that access were the trustees. The white trustees of the Freedman's Bank had watched the numbers deteriorate across months. This was not a sudden revelation that arrived with the panic of 1873. The financial condition of the institution had been declining in a documented and traceable way for an extended period before the panic arrived. Loans that had been extended were not being repaid. The percentage of overdue accounts had grown steadily. The cash reserves in the vault had been shrinking. The gap between what the bank owed its depositors and what the bank actually held in recoverable assets had been widening in ways that the ledgers recorded clearly for those who chose to read them carefully. The trustees had access to those ledgers. That is not an assumption. It is a description of their formal institutional role. They were appointed specifically to provide oversight. Oversight requires information, and the information was there. It existed in the records of the institution they were responsible for managing. Whether all 50 trustees examined those records with equal attention is a separate question, one the historical record does not answer cleanly. But the people in the most active positions of financial authority within the institution, the people making lending decisions and approving transactions, understood the direction the numbers were moving. By early 1874, that direction was no longer ambiguous. The institution was, in practical terms, already dead. What happened next is worth examining carefully, because the response of the trustees to that knowledge is one of the most documented and most debated aspects of this entire story. And their response was not what the stated purpose of the institution, or the basic obligation to the people whose money they held, might suggest it should have been. They did not confess. There was no public statement from the Board of Trustees acknowledging the condition of the bank's finances. No announcement to depositors explaining that the institution was in serious difficulty. No communication directed at the 61,000 people who held accounts, people who, in many cases, were still making deposits during this period, still adding money to an institution whose trustees already understood was unable to protect it. The absence of that communication is itself significant. These were people with no other financial institutions welcoming them, no comparable alternatives, no safety net to fall back on if the bank failed. The information that the trustees held about the bank's condition was precisely the kind of information those depositors needed to make decisions about their own savings. It was not shared with them. They did not return the money, the funds that had flowed out of the institution through the transactions of the preceding years, the railroad bonds, the Sandstone Company loans, the headquarters construction, the personal loans to associates, were not recovered or restored. There was no documented effort to recapture the deposits that had been placed into arrangements that had since proven worthless or irrecoverable. The vault remained nearly empty. The outstanding loans remained largely uncollectible, and the trustees who had overseen the decisions that produced that outcome took no documented action to address the gap between what depositors were owed and what the institution actually held. They did not warn anyone. That is perhaps the most difficult aspect of this period to set aside without comment. Across 37 branches in 17 states and Washington, D.C., depositors were continuing to engage with the bank as though it were a functioning institution. They were making deposits. They were checking balances. They were operating on the reasonable assumption that an institution chartered by Congress, endorsed by the government, and overseen by 50 trustees was in a condition consistent with the trust they were placing in it. The trustees knew that assumption was incorrect. They chose, in the months before the final collapse, not to correct it. Instead, they resigned, and in March of 1874, they installed Frederick Douglass as president of the Freedman Savings and Trust Company. The choice of Frederick Douglass requires some context to fully appreciate, not because his identity is unclear, but because the specific weight of his name and public standing in 1874 is easy to underestimate from a distance of 150 years. Douglass was not simply a prominent figure. He was the most recognizable black man in America, a man who had been born into slavery, had taught himself to read in defiance of laws prohibiting it, had escaped, had built a public career as an abolitionist speaker and writer whose influence extended across the country and into international audiences. His autobiography had been read widely. His speeches had been reproduced in newspapers. His name carried moral authority that was, in the context of post-emancipation America, arguably unmatched by any other single individual. Inside the black community specifically, his name meant something that went beyond fame in the ordinary sense. He represented the possibility that freedom was real, that it could produce lives of dignity and accomplishment, that the promise of emancipation was not merely a legal change, but a genuine transformation in what was possible for black Americans. When Frederick Douglass was associated with something, that association carried the weight of everything his life had demonstrated. His name was not just a name. It was an argument, a living proof that the system the Freedmen's Bank claimed to serve was capable of producing people worth trusting and institutions worth investing in. The trustees chose that name. They placed it at the head of an institution they already knew was beyond saving. He walked into the headquarters on Lafayette Square in Washington, D.C. The building sat directly across from the Treasury building, near the White House, on a block that projected exactly the kind of official permanence and governmental proximity that the bank had always used to signal its legitimacy. Douglass later described his first impression of the building, its towering height, its perfect appointments. He wrote that he felt, upon entering it, something like the Queen of Sheba experiencing the riches of Solomon. That description, recorded in his own words, is worth sitting with. He walked into that building as a man who had spent his life fighting for the people the institution claimed to serve. He walked in believing, based on everything visible about the place and everything the trustees had communicated to him, that there was something real inside worth leading. He invested $10,000 of his own personal money into the institution. That detail is documented and significant. $10,000 was a substantial sum in 1874. It was not a symbolic gesture. It was a genuine financial commitment made by a man who, based on the information available to him at the time of his appointment, believed the institution had a future worth investing in. The trustees who installed him had the information that would have changed that calculation. They did not share it with him before he made the investment. Then he opened the books. And this is where the explanation becomes difficult, not because what he found is unclear, but because what he found forces a direct confrontation with what the trustees must have known before they asked him to take the position. He found what he later described as a corpse. That word, chosen by Douglass himself in his own subsequent writings about the experience, is precise. Not a struggling institution, not a bank facing serious challenges that strong leadership might address. A corpse, an entity that had already ceased to function in any meaningful sense before he arrived. The specific numbers he encountered are recorded. Outstanding loans far exceeded deposits. The debts on the books were, in significant proportion, debts that would never be repaid, loans to entities that had already failed or were in the process of failing. The actual cash remaining in the vault was less than $50,000. The bonds held by the institution amounted to $400. $400 in bonds against $2.9 million owed to 61,000 depositors. That is not a difficult shortfall to address through better management. It is a description of an institution that had, long before Douglass arrived, already transferred the savings of its depositors into arrangements from which those savings would not return. He told Congress to shut the bank down. The closure was authorized, and on June 29, 1874, the Freedman Savings and Trust Company closed its doors permanently. The institution that had opened in 1865 with the backing of Abraham Lincoln, the promise of the United States government, and the trust of 4 million newly freed people, closed 9 years later with less than $50,000 in cash and 61,000 depositors holding accounts that could not be honored. Douglass served as president for barely 6 weeks, but the question of what those 6 weeks represented, and what the decision to appoint him actually reflected, is one that remains genuinely unresolved in the historical record. At first, it seems like a straightforward, if desperate, attempt at institutional rescue. The trustees were facing a collapsing bank. They needed someone with credibility and public standing to lead a recovery effort. Douglass had credibility. He had standing. Perhaps they believed, however unrealistically, that his name and presence could attract new deposits, restore public confidence, and create enough breathing room to address the financial crisis. Some historians have argued for this interpretation, that the appointment was a genuine if misguided attempt to save the institution rather than a deliberate act of misdirection. But there's a problem with that interpretation. It requires believing that the trustees who installed Douglass did not fully understand what the books showed. And the books, by early 1874, showed something that did not require sophisticated financial analysis to read. 75% of loans overdue. A vault nearly empty. Records that independent examiners later described as largely fictional. The trustees had access to those numbers. The gap between what the institution owed and what it held was not a subtle discrepancy that might escape notice. It was the kind of imbalance that anyone examining the ledgers honestly would have understood immediately, which raises the question that the official explanation has never fully resolved. If the trustees understood what the books showed, and the evidence suggests they did, then installing Frederick Douglass as president was not an act of institutional rescue. It was something else. It placed the most recognizable black man in America, whose name carried the moral authority of a lifetime spent fighting for black freedom, at the head of an institution that was already beyond saving. When the collapse came, and the trustees, based on what they knew, understood the collapse was coming, the face that depositors would remember was not Henry Cook's. It was not Jay Cook's. It was Frederick Douglass. Whether that outcome was the intended result of a deliberate decision, or simply the consequence of a desperate choice made without full consideration of its implications, is a question the surviving record approaches without answering definitively. Both possibilities are supported by portions of the available evidence. Neither has been conclusively established, and that uncertainty, sitting at the center of a decision that shaped how 61,000 people understood what had happened to their savings, is one of the most unresolved details in a story that contains several. The question remains open, and open questions, particularly ones involving this much-documented context, tend to resist comfortable closure. The collapse of the Freedman's Bank on June 29, 1874, did not end the story. In some ways, it only extended it into a series of subsequent events that are, in their own way, equally difficult to explain through the frameworks most commonly applied to institutional failure. What happened after the doors closed is a separate chapter in the record, and it raises questions that the narrative of an unfortunate financial collapse does not fully address, because what followed the closing was not simply the aftermath of a tragedy. It was a decades-long sequence of decisions, blocked remedies, and unanswered recommendations that shaped the outcome for 61,000 people across nearly half a century. Congress investigated. That response, at least, was what the situation appeared to require. An institution chartered by the federal government, created to serve a specific and vulnerable population, had collapsed with $2.9 million belonging to 61,000 depositors unaccounted for. The men who had overseen the decisions that produced that outcome were identifiable. Their roles were documented. The transactions that had moved depositor funds into irrecoverable arrangements were recorded in the ledgers that investigators could examine. A congressional investigation was the appropriate institutional response, and it proceeded accordingly. The investigation found what the ledgers showed. It examined the transactions, traced the money flows, identified the individuals in positions of authority over the decisions that had depleted the vault, and reached conclusions about what had occurred. The investigation recommended indictments. Specifically, it recommended indictments for Henry Cook and others involved in the mismanagement of the bank's funds. The recommendation was clear. The basis for it was documented. The path from investigation to legal accountability appeared, at that point, to be straightforward. Not a single white trustee was ever charged with a crime. Not one. Not Henry Cook, whose simultaneous positions on the Finance Committee, in the territorial governorship, and at First National Bank had placed him at the center of the transactions under investigation. Not any of the other trustees who had approved personal loans, directed depositor funds toward affiliated companies, and resigned without warning depositors about the condition of the institution they were leaving behind. The investigation that recommended indictments produced 0 prosecutions, 0 trials, 0 legal consequences for the people whose documented decisions had resulted in the loss of $2.9 million belonging to 61,000 people who had no other financial institutions to turn to. That outcome is difficult to explain through the ordinary logic of institutional accountability. Investigations that recommend indictments generally do so because the evidence supports prosecution. The recommendation itself indicates that investigators believed the documented record met the threshold for legal action, but the legal action never followed. The gap between the recommendation and the outcome, between what the investigation concluded and what the justice system produced, sits in the record without a clear explanation. Some historians have attributed it to the political environment of the period, to the relationships between the people implicated and the people responsible for pursuing charges, and to the broader rollback of Reconstruction-era accountability that was occurring simultaneously across multiple domains. Whether those contextual factors constitute an explanation or simply a description of the conditions under which accountability failed is a distinction worth maintaining. There's also a detail that sits outside the main sequence of the investigation and deserves specific attention. A secret loan of $33,366 was approved the day after the bank formally closed. The day after, the institution had officially ceased operations. Its doors were closed. Its depositors had been told the bank was no longer functioning. And on the following day, someone approved a loan of that specific amount without legal authority, without notifying the trustees, without any documented justification, and without any subsequent consequence for the person who approved it. The loan appears in the records. The identity of the person who approved it, George Stickney, acting in his capacity as an officer of the now-closed institution, is documented. What is not documented is any legal or professional consequence that followed from the approval of a loan made without authority from an institution that had already closed. That detail sounds minor at first, until it is examined more closely. A loan approved the day after a bank closes, without authority, without notification, without consequence, is not a bureaucratic error. It is a transaction made by someone who understood that the normal oversight mechanisms were no longer operating and who proceeded anyway. The fact that it left no trail of accountability is consistent with the broader pattern of accountability that characterized the entire history of the institution. But its timing, one day after closure, gives it a specificity that the general pattern of mismanagement does not fully explain. Between 1882 and 1920, bill after bill was introduced in Congress to reimburse the Freedmen's bank depositors with federal funds. This legislative effort extended across nearly 4 decades. It was not a single attempt that failed and was abandoned. It was a sustained, repeated effort involving multiple members of Congress across multiple sessions, multiple administrations, and multiple political environments. The bills differed in their specific provisions, but shared a common purpose: to use federal resources to compensate the 61,000 people whose savings had been lost inside a federally chartered institution, and their descendants who had inherited that loss. Several sitting presidents expressed support for the reimbursement effort during this period. Presidential support for legislation does not guarantee passage, but it does represent a level of institutional endorsement that typically carries weight in congressional deliberations. The support existed. The bills were introduced, and every single one was blocked, without exception. For nearly 4 decades of sustained legislative effort, not one reimbursement bill reached passage. The blocking was documented and its source was identifiable. White Southern members of Congress opposed the bills consistently and successfully across the entire period. This is where the explanation becomes difficult. A single block bill might reflect ordinary legislative politics, competing priorities, procedural obstacles, insufficient support at a particular moment. 2 or 3 block bills might reflect a sustained political disagreement about the appropriate use of federal funds. But the consistent blocking of every bill introduced over a period of nearly 40 years by a specific and identifiable group of legislators, producing a specific and identifiable outcome for a specific population of people, begins to look like something more organized than the ordinary friction of the legislative process. Some historians describe it as exactly that: a coordinated and sustained effort to ensure that the people who lost money in the Freedmen's bank collapse would not receive compensation from a federal government that had chartered the institution. Others maintain that the blocking reflected broader political disagreements about federal spending and Reconstruction-era commitments rather than a targeted effort to prevent restitution specifically. Both interpretations are represented in the scholarly literature. Neither has resolved the basic fact that every attempt failed. In 1927, the Treasury Department announced that the remaining assets of the Freedmen's Bank, whatever had been recovered and held through the preceding decades, were fully depleted. No further payments would be available. The case was, in the Treasury's official language, considered closed. That announcement came 53 years after the bank's collapse. 53 years after 61,000 people lost access to their savings. In that half-century, partial payments had been made. Estimates suggest depositors received somewhere between 30 and 60% of what they were owed, depending on the account and the branch, but the remainder was simply declared unavailable and the matter officially concluded. That declaration of closure did not reach everyone who was still waiting. A man named Henry Thomas was still writing letters in 1939, 65 years after the bank closed. He was writing to the NAACP, asking the organization to lobby Congress on behalf of his family for the 38% of their deposits they had never received. 38%. Not a complete loss. Some amount had been paid, but 38% remained outstanding, and Henry Thomas, in 1939, was still trying to recover it through whatever channels were still available to him. The Treasury had declared the case closed 12 years earlier. Henry Thomas had not. That image, a man writing letters in 1939 about money his family deposited before 1874, is not an abstraction. It is a specific, documented person pursuing a specific, documented claim through the only means still available to him. And it raises a question that sits underneath the entire post-collapse sequence. When does an unresolved injustice become resolved by the simple passage of time? At what point does the absence of accountability become the permanent condition rather than a temporary failure of the system to function as intended? The official answer, delivered by the Treasury in 1927, was that the case was closed when the assets were depleted. The unofficial answer, demonstrated by Henry Thomas writing letters in 1939, is that closure declared by institutions is not necessarily closure experienced by the people the institutions affected. Those two answers have never been reconciled, and the gap between them is one that the official history of the Freedmen's Bank tends to minimize. When an injustice requires sustained effort to maintain across 40 years of legislative blocking, something worth examining is present in that effort. Ordinary legislative failure, bills that do not pass because of insufficient support or competing priorities, does not typically require consistent, organized blocking across multiple decades. Bills that lack support simply do not pass. Bills that face organized opposition across 40 years of sustained effort are a different category of legislative outcome. The distinction matters because it affects how the result is understood. An outcome produced by organized, sustained opposition across 4 decades is a different kind of outcome than one produced by ordinary institutional inertia. Some believe the 40 years of blocked legislation reflects exactly what it appears to reflect, a coordinated and sustained effort to ensure that a specific group of people did not receive compensation for a specific loss. Others argue that the pattern reflects the broader political dynamics of the post-Reconstruction era, in which federal commitments to formerly enslaved people were systematically rolled back across multiple domains simultaneously, and that the Freedmen's Bank reimbursement effort was one casualty among many rather than a specifically targeted outcome. Both interpretations are supported by portions of the historical record. Neither fully explains every aspect of what the documentation shows. What the documentation shows clearly is the sequence: investigation, recommended indictments, 0 prosecutions, a secret post-closure loan without consequence, 40 years of blocked reimbursement bills, a Treasury declaration of closure in 1927, a man writing letters in 1939. Each element of that sequence is documented. Each one raises questions that the simple narrative of an unfortunate financial collapse, overtaken by economic panic, and eventually resolved through normal institutional processes, does not fully answer. The gap between what the investigation recommended and what accountability produced. The gap between what the reimbursement bills proposed and what Congress allowed to pass. The gap between what the Treasury declared closed and what Henry Thomas was still pursuing 12 years later. Those gaps are in the record. They have been in the record for over 150 years, and they remain, even now, without the kind of resolution that the documented sequence of events would seem to require. There are different ways to interpret what happened to the Freedmen's Bank. That statement is not a way of avoiding the question. It is an accurate description of where the historical record actually leaves us. The documents exist. The transactions are recorded. The names of the people involved are known. The timeline is traceable from the bank's founding in 1865 through the collapse in 1874 and the decades of blocked reimbursement that followed. And yet, after more than 150 years of that evidence sitting in archives available to researchers, historians, and anyone willing to look, the interpretations of what those documents mean have not converged on a single agreed conclusion. That disagreement is itself worth examining, because it tells us something about the nature of the evidence and about the limits of what documentary records alone can establish. The first interpretation, the one most commonly offered in general historical accounts, holds that what happened to the Freedmen's Bank was primarily a market failure. This reading begins with the Panic of 1873 and treats it as the central causal event. The panic was real and its scale was significant. It was not a minor financial disruption. It was a systemic crisis that moved through the American economy with speed and force, collapsing institutions that had appeared stable, drying up credit across entire sectors, and producing levels of unemployment and economic disruption that affected millions of people across the country. Thousands of banks and businesses failed during this period. The Freedmen's Bank was one of them. From this perspective, placing the Freedmen's Bank collapse in a special category, treating it as the product of something more deliberate than economic misfortune, risks imposing a narrative on events that were, at their core, driven by forces that nobody fully controlled. This interpretation also acknowledges that the bank was poorly managed. Incompetent or negligent oversight allowed the institution to become exposed to exactly the kinds of risks that the original charter was designed to prevent. Decisions were made that look obviously bad in retrospect. Funds were placed in ventures that carried more risk than a bank serving vulnerable depositors should have accepted. These were failures of judgment in this reading, more than anything else. And judgment failures, while serious, are different in nature from deliberate wrongdoing. The market failure interpretation does not require anyone to have intended the outcome. It only requires a combination of poor decisions and bad timing to produce a catastrophic result. But others point to the structure of the collapse, and they raise questions that the market failure interpretation does not fully address. Their argument begins not with the Panic of 1873, but with the original charter, the founding document of the institution, and what that document did and did not contain. The charter established 50 trustees, with no personal liability, for the faithful discharge of their duties. It contained no penalties for mismanagement. It provided no mechanism through which depositors could hold anyone accountable if the institution failed to protect their money. These were not gaps that developed over time through gradual institutional drift. They were present in the document from the beginning, signed into law on the same day as the broader Freedmen's Bureau legislation that accompanied the end of the Civil War. The structural argument holds that those absences were not accidental, that a charter written with genuine protective intent for the most vulnerable depositors in the country would have included the kinds of accountability mechanisms that the Freedmen's Bank Charter specifically lacked. Personal liability for trustees creates a direct incentive for careful management. Penalties for mismanagement create consequences that deter poor decisions. Depositor protections create mechanisms for accountability when those deterrents fail. The absence of all three in a single document, written for people who had no legal experience and no alternative institutions available to them, raises a question that the market failure interpretation tends not to ask. Was that structure an oversight, or was it a design choice? Some researchers have argued that it was a design choice, not necessarily a malicious one in every case, but a deliberate one, that the charter was written in a way that created the appearance of a protected institution without building in the mechanisms that would have made that protection real. An institution that looked like a government-backed safe haven, carried the imagery of Lincoln and Grant, used language like benevolent institution in its public materials, but whose founding document left the people managing it entirely unaccountable for what they did with the deposits in their care. Whether that structure was chosen because it served the interests of the people who would manage the bank, or because the legislators who drafted the charter simply did not think carefully enough about what genuine protection required, is a question the document itself cannot answer. A third interpretation focuses not on any single element of the story, but on the pattern that emerges when all the elements are placed in sequence together. This reading does not begin with the charter or with the panic. It begins with the observation that certain features of this story appear too consistently, across too many different moments and decisions, to be explained comfortably as coincidence or accumulated misfortune. The same man lobbied Congress for the charter amendment that expanded depositor risk. That same man controlled the finance committee that directed the resulting loans. That same man was simultaneously president of the bank that received a significant portion of those deposits. The amendment that made the loans possible was approved without any additional oversight. The loans that followed moved funds consistently toward ventures connected to the man making the lending decisions. The resignation of that man's brother's firm triggered the panic that destroyed the institution. The trustees who had watched the deterioration for months resigned without warning depositors and installed the most recognizable black figure in America as president 8 days before the final collapse became public. Every subsequent attempt at reimbursement was blocked for 40 years by a specific and identifiable group of legislators. Some researchers look at that sequence and use the word coordinated. They argue that the pattern is too consistent and too directional to be the product of unrelated decisions made independently by different people in different positions. That the movement of money, the timing of resignations, the choice of Douglass, and the sustained blocking of reimbursement bills form a connected sequence that reflects something more organized than ordinary negligence or market exposure. This interpretation does not require a formal conspiracy with documented meetings and explicit agreements. It requires only that people in positions of overlapping authority made decisions that consistently served their shared interests and consistently failed the depositors whose money they controlled. Others call the same pattern opportunistic rather than coordinated. In this reading, the people involved were not executing a plan so much as exploiting a structure that made exploitation easy. The charter had no accountability mechanisms. The political environment of the early 1870s did not enforce strict boundaries between overlapping financial roles. The depositors had no legal recourse. When opportunities arose to direct funds in favorable directions, they were taken, not because anyone had designed the situation from the beginning with that outcome in mind, but because the situation presented itself and the structural conditions made exploitation the path of least resistance. Opportunism and coordination can produce similar outcomes through different processes, and the surviving records do not clearly distinguish between them. Others still insist that the evidence supports only negligence, that the charter's structural gaps reflected the standards of institutional design common to the era, that Henry Cook's overlapping roles, while problematic by modern standards, were not unusual for a period when the boundaries between public office and private financial interest were poorly defined across the entire financial system, that the loans to affiliated ventures reflected the informal networks through which capital moved in Washington during that period rather than deliberate self-dealing, that the panic, when it arrived, overwhelmed an institution that had been poorly managed without being deliberately exploited, and that the subsequent blocking of reimbursement bills reflected the broader political dynamics of post-Reconstruction America rather than a specific and organized effort to deny justice to Freedman's bank depositors in particular. This interpretation has its own difficulties. The negligence reading requires accepting that a remarkable number of bad decisions were made by the same small group of people across a sustained period, all moving in the same direction, all benefiting the same set of connected interests, without any of those decisions reflecting intentional self-dealing. That is possible. Negligence can be systematic and directional without being deliberate, but the consistency of the pattern, decision after decision, across years, all pointing the same way, creates an explanatory burden that the negligence framework carries with increasing difficulty as the full sequence is examined. What makes this case genuinely difficult to resolve is not a lack of evidence. It is the nature of what the evidence can and cannot establish. The documents show what happened. They show the transactions, the timing, the positions of the people involved, and the outcomes those decisions produced. What the documents cannot show, on their own, is intent. They cannot tell us what Henry Cook understood about the consequences of his decisions when he made them. They cannot tell us whether the trustees who installed Frederick Douglass did so knowing he would become the public face of a collapse they had already ensured, or whether they were genuinely hoping his presence might prevent it. They cannot tell us whether the legislators who blocked reimbursement bills for 40 years were responding to a coordinated political strategy or to the ordinary pressures of their constituencies and political alignments. All three interpretations, market failure, structural design, coordinated pattern, are partially supported by the surviving records. Each one accounts for some portion of what the documents show. None of them fully explains every detail. The market failure reading accounts for the panic, but not for the pre-panic decisions that made the panic fatal to this particular institution. The structural design reading accounts for the charter's accountability gaps, but cannot establish whether those gaps were intentional or incidental. The coordinated pattern reading accounts for the consistency of the sequence, but cannot distinguish coordination from opportunism or sustained negligence from sustained self-interest. And the people who could have answered the hardest questions were never put under oath in a courtroom. That fact sits at the center of the interpretive problem. Congressional investigations can recommend indictments. They cannot compel testimony under the conditions that legal proceedings create. The trustees who oversaw the bank's decline, the men who made the lending decisions, the person who approved a loan the day after the bank closed, none of them were ever placed in a situation where the full weight of legal accountability required them to explain their decisions in detail and under oath. The record they left behind is the record of what they chose to document, in documents they controlled, what they understood, what they intended, and what they discussed in conversations that were never written down, is not in the archive. That is not an unusual condition for historical investigation. Most historical questions are answered from incomplete records. But in this case, the incompleteness sits at precisely the point where the most important questions live, the gap between what the transactions show and what the intentions behind them were. And that gap has remained open for more than 150 years, not because the documents have not been examined, not because researchers have not tried to close it, but because the evidence available, while substantial and detailed, reaches only so far. It shows the what with considerable clarity. It approaches the why with increasing uncertainty, and the how deliberately. The question of whether what happened to 61,000 depositors was accidental, opportunistic, or planned remains, even now, genuinely unresolved. The Freedman's Bank building stood on Pennsylvania Avenue for decades after the institution inside it collapsed. It occupied one of the most prominent addresses in Washington, D.C., directly across from the Treasury Building, visible from the White House, on a street that functioned as the physical spine of federal power in the United States. The building had been constructed with depositor money. Its towering height and carefully appointed facade had been paid for by the $5 deposits of formerly enslaved wage earners who believed they were investing in an institution that would protect their savings. For 25 years after the bank closed, that building continued to stand on that corner, a large, visible, permanent structure at the center of the capital city, paid for by people who never received their money back. It was demolished in 1899, 25 years after the collapse. The Washington Post, covering the demolition, ran a headline that described the building as a monument of a crime. That phrase, chosen by a newspaper, not by a historian or an advocate, but by a publication covering the physical removal of a structure, is worth pausing on. Monument of a crime. Not a monument to mismanagement, not a monument to financial misfortune or economic panic. A monument of a crime. The language is specific. It implies a judgment about what occurred inside that institution that goes beyond the vocabulary of market failure or institutional negligence. Whether the newspaper intended that phrase as a precise legal characterization or as a broader moral description is unclear, but the phrase was chosen and published, and it is the phrase that the historical record has preserved from that moment. In 2016, the Treasury Department renamed the building currently occupying that site the Freedman's Bank building. A plaque marks the corner. The renaming was presented as an act of historical recognition, an acknowledgement that something significant had occurred on that location, that the people affected by it deserved to be remembered, and that the institution responsible for overseeing the site had some relationship to the history attached to it. These are not meaningless gestures. Recognition has value. Names matter. Plaques in public spaces serve a function in how communities relate to their histories. But this is where it becomes unclear. The gap between what happened at that location and what the plaque represents is significant. $57 million in today's equivalent. 61,000 depositors. 0 prosecutions. 40 years of blocked reimbursement legislation. A Treasury declaration in 1927 that the case was closed. A man writing letters in 1939 still pursuing 38% of his family's deposits. Against that sequence, a renamed building and a corner plaque represent a particular kind of historical memory, one that acknowledges the event without engaging with the questions the event leaves behind, whether that is the appropriate response to what the records document, or whether it represents a continuation of the pattern of insufficient accountability that characterized the decades following the collapse, is a question that reasonable people have answered differently. Inside the National Archives, the records survive. That fact sits somewhat separately from the story of the building and the plaque, and it deserves its own careful attention. The ledgers of the Freedman's Bank, the deposit registers, the account books, the personal information collected from every depositor across 29 surviving branch locations were not destroyed when the institution collapsed. They were preserved. They passed into federal custody and eventually into the archive system, where they have been cataloged, digitized, and made searchable through platforms that allow anyone with an internet connection to access them today. The records contain approximately 480,000 individual names. The scale of that number requires some context. These are not 480,000 records of transactions or account balances. They are 480,000 names of human beings, individuals who walked into a branch, sat down with a cashier, provided their personal information, and opened accounts in the belief that the institution was safe. Each record contains a name, a birthplace, a current residence, an occupation. Many contain the names of spouses, children, parents, and siblings. For formerly enslaved depositors, the records sometimes include the names of former owners and the plantations where they had been held, information that the bank collected because it needed to identify depositors or their heirs in the event of death or dispute. For the vast majority of the people whose names appear in those ledgers, the Freedman's Bank record is the first time they appear in any official document at all. Before emancipation, enslaved people were not listed by name in federal censuses. They could not file marriage certificates. They did not appear in land records or legal documents as individuals with identities the state recognized. They existed in the official record primarily as property belonging to someone else. The bank deposit registers changed that. For the first time, these individuals were documented as people, with names, with families, with residences, with occupations, with savings. The records created by an institution that simultaneously failed to protect their money are, for hundreds of thousands of people, the foundational document of their existence in the official historical record. Historians who work with African American genealogy describe the Freedman's Bank records as among the most significant primary sources available for researching Black family history from the post-emancipation period. The records have helped families trace ancestors separated during slavery, identify family connections that were severed and never formally restored, and establish the existence of individuals who would otherwise appear nowhere in the documentary record. The archive is, in this specific sense, genuinely valuable. It has served a real and important function for the descendants of the people who deposited at the bank. And yet the relationship between the records and the institution that created them is complicated in a way that does not resolve easily. The same bank that took the money preserved the names. The same institution that failed its depositors through a sequence of decisions that stripped their savings created, as a byproduct of its administrative requirements, the most comprehensive record of post-emancipation Black family life known to exist. Those two facts coexist in the same archive, in the same ledgers, and they do not sit comfortably alongside each other. The records were not created as an act of historical preservation. They were created because the bank needed to identify account holders. The preservation of those records after the collapse was not a deliberate effort to honor the depositors. It was the ordinary process by which institutional documents pass into federal custody. The historical value of the archive was a consequence, not an intention. The men who restructured the bank, who lobbied for the charter amendment, who approved the loans, who sat on multiple boards simultaneously, who resigned without warning depositors, who were recommended for indictment and never charged, are largely forgotten by the general public. Henry Cook's name does not appear in most standard accounts of American financial history. J. Cook is remembered primarily for his role in financing the Civil War, not for the Freedman's Bank transactions that followed. The trustees who oversaw the bank's decline are, for the most part, not names that appear in the broader historical memory of the period. The depositors' names endure. In an archive, in a database, searchable, available, preserved by the institution that took their money in ledgers that outlasted the vault that was supposed to hold it. That inversion, the forgotten perpetrators, the preserved victims, is one of the more unusual features of this particular historical record, and it raises a question that is difficult to answer cleanly. What does it mean for names to survive when the savings they represent did not? The archive preserves the identity of 61,000 people and their families. It does not restore what was taken from them. The historical record of who they were exists in considerable detail. The historical accountability for what happened to their money exists in considerably less. But the larger questions that this story generates remain genuinely open. They are not questions that additional archival research is likely to close, because they are not primarily questions about facts. The facts are largely established. The questions are interpretive, about what the facts mean, about how the documented sequence of events should be characterized, about what the appropriate framework is for understanding an outcome that affected specific people in specific ways across a documented period of time. When a charter is written without accountability mechanisms and nobody asks why, the question of whether that represents negligence or intention is not answered by the charter itself. The document shows what was included and what was absent. It does not explain the reasoning behind those choices. The people who made those choices left no clear record of their thinking. And so the question remains open, not because the evidence is insufficient to establish that the gaps existed, but because the evidence cannot reach the intentions that produced them. When investigations produce recommendations, but no charges follow, the question of what that tells us about the system conducting the investigation is similarly unresolved by the documentary record alone. The investigation is documented. The recommendations are documented. The absence of prosecutions is documented. What is not documented is the reasoning, the specific decisions made by specific people at specific moments that transformed a recommendation for indictments into a complete absence of legal consequences. That reasoning, if it was ever recorded, has not survived in accessible form, and without it, the gap between recommendation and outcome can be attributed to institutional failure, to political influence, to the racial dynamics of the post-Reconstruction justice system, or to some combination of all of these, without the record clearly establishing which explanation is most accurate. When 40 years of block legislation produces a specific outcome for a specific group of people, the question of how to categorize that outcome is one that the historical record approaches, but does not definitively answer. The bills are documented. The blocking is documented. The consistency across 4 decades is documented. What is not documented, with the kind of clarity that would settle the interpretive question, is whether that consistency reflected organized coordination, shared political interests that happened to align, or the ordinary operation of a legislative system that was systematically structured against the interests of the people the bills were meant to help. W.B. Du Bois addressed this in 1903, writing that the collapse of the Freedmen's Bank did more damage than 10 additional years of slavery could have done. He was not making a claim about physical suffering or legal status. He was making a claim about something more difficult to measure, about faith, about the damage done to the belief that freedom meant something durable, that institutions could be trusted, that the government's promise had weight behind it. Du Bois understood, writing less than 30 years after the collapse, that the loss the bank represented was not only financial. It was the loss of the first proof that black labor had value in a free economy, the loss of the belief that saving was possible, that tomorrow could be built from today, that participation in the formal economy was open in the ways the bank's advertisements had promised. Whether that damage was accidental or deliberate is a question that the available evidence has never cleanly answered. After 150 years of the records sitting in archives, after generations of researchers examining the ledgers and the congressional documents and the biographical records of the people involved, the question of intent, of whether what happened to 61,000 depositors was the product of negligence, opportunism, or deliberate coordination, remains open in the way that questions remain open when the people who could answer them were never required to do so under conditions that demanded honest answers. And perhaps that uncertainty itself is part of the story, not a failure of historical research, not a gap that better archives would close, but a feature of the record that reflects something about how accountability was structured, or not structured, around these particular events and these particular people. The records that survive show the depositors clearly. Their names, their families, their savings, their trust. The records that survive show the transactions clearly. The money, the movement, the timing, the outcomes. What the records do not show clearly is the internal reasoning of the people who made the decisions that connected those two things. And that absence, the gap between the documented what and the unestablished why, has been present in this story from the day the bank closed. It remains present now, and it raises a final question that is perhaps the most difficult one this story generates. When a historical record is complete enough to show exactly what happened to people, but incomplete in precisely the ways that would establish accountability for why it happened, is that an accident of preservation, or is it a different kind of answer altogether?